Good evening and welcome to episode 4 of Afrolantican Jurisprudence. I am your host, Professor Smith, Smitty Vonta, Andre Smith. Everybody knows what you can call me, anything you'd like, just about anyway. So today's episode, we've introduced the project. We've talked about black capital accumulation, how Afrolantican jurisprudence, at least my conception of it, would respect rights to property and therefore would be designed, or at least the jurisprudence that I would design would guard against material subordination or structural racism or structural group subordination. And I hope to continue that as the theme behind Afrolantican jurisprudence. But when we talked about black capital accumulation, we're kind of talking about private ordering more so than government, right? We're talking about the structure of government and how it facilitates the market, how it facilitates economics. So we talked about the distinctions between capitalism, socialism, communism. They're more subtle than one suggests. But today we're going to talk instead of economics, we're going to talk about law, right, and the philosophy of law and the theory of law and what law is, right, from an epistemological or metaphysical, however you want to describe it, what it is, not what laws are, what the laws are, but what is law itself, right? And again, the point being that we want to make our jurisprudence not consistent from its core to its prescript, right? From what we're asking the jurisprudence to do, how we're describing it, all the way it should be consistent to how we even conceive of the law. And conceiving of it, we're going to talk about law as an aesthetic later, because that's what we're really doing, right? We're talking about how do we visualize it in a way that's coherent and consistent throughout. And so I offer the argument, or I contend that, or I agree with, how about that? I agree with the conception of law as an autopoietic system. Law as an autopoietic system. All right. So I'm going to take it from there and try to describe it, autopoiesis, law, and whatnot. And the interesting thing is, hopefully, to keep your attention, what we're going to do before we talk about law is we're going to talk about hip hop. Right? That's another one of the nations to which I belong. And I'm very proud that hip hop was created during my lifetime. And feel like I participated in it in an earlier stage of my life. And I get to help define it, right? I feel like I'm a part of it. But the question becomes, what is it? What is my role in defining hip hop? So we're going to compare what is hip hop with what is law. And so we're going to use the theory of autopoiesis to describe both, to give you kind of a sense of what we're talking about with autopoiesis, and then talk about what we do with the law. So let's, ready to go? Let's go. All right, Afrolantican jurisprudence recognizes law as an autopoietic system, which means that once set in motion, law, like anything else, becomes a system of discourse that becomes a thing distinct from its environment, which reproduces itself based on its own internal logic, yet it observes and adapts to its environment. Right? That's what we mean by law as an autopoietic system. Afro-Atlantic jurisprudence recognizes that in this way the law is alive. Right? Some of my fellow theorists in law schools may defend the living Constitution. Well, I think you're not going far enough, that we need to describe the law as alive. I even had a discussion with someone about whether interpretation in law is epistemological or is it hermeneutics. And they insisted that it was hermeneutics, but if you do that, then you're insisting that the law is positive, that the law is what is written. And I'm not sure we want to go down that route. And so autopoiesis is a theory that describes the law as alive to preserve its structure and whatnot. So let me continue. Positivism and formalism represents the law's bones and structure, while realist constructs like purposivist judging, or even let's say the Chevron doctrine, as far as administrative law, allows the law to see outside of itself, the consequences which it produces. Right, and it has to, right, because as a living thing, yes, you are distinct from your environment, although to the extent you do not observe and adapt to that environment, you're headed for desuetude, your extinction, perhaps uselessness, right? So, notwithstanding that observation, there is still the reason I enjoy autopoiesis, or I believe it's the correct aesthetic described Afrolantican jurisprudence, is because it's also consistent with critical theory and public choice theory, right? Two seemingly opposing, or at least the people that uh, uh, um, promote each discipline or each theory are usually politically at odds. However, they both fit within this theory of autopoiesis because factions and forces in the environment inject or feed the system of law with discourse designed to alter its operations towards a basically more or less unstated purpose. Could be stated or unstated, but usually a stated purpose. That is how the law goes in a public choice environment, right? That elitism, white supremacy, or whatnot is never stated. And as a matter of fact, again, we'll talk later about Straussians, followers of Leo Strauss and the neoconservative movement, and his insistence that the philosophers and the people that think deeply about the subject never reveal their true intentions, right? To always have a hidden agenda that the vulgar, those who are uneducated, can't decipher. All right. So Afrolantican jurisprudence represents my attempt to set in motion a Black nationalist jurisprudence, which I suggest should recognize the importance as well as the flaws of formalism and realism, as well as the insights of critical legal theory. That the Supreme Court of Afrolantica, if I were a member, would reject what I would call deliberative chauvinism and expressly apply each of the techniques of legal interpretation, recognizing that the system of law requires the stability and structure that textualism provides, that the intent of the people and its representatives provide extremely important context to consider, especially if you're to call yourself a democracy, that the consequences of law should also be considered, both intended and unintended. Because as critical legal studies teaches us, forces outside the law will always attempt to inject devices into the system that perpetuate subordination. So that's the theory or describing law, Afro-Atlantic jurisprudence, or this law generally as autopoietic, where we differ. So Afro-Atlantic jurisprudence differs from American jurisprudence in terms of autopoiesis because it insists on considering unintended consequences as a means to combat hidden agendas. So we're suggesting that the organs or that which in the law that allows it to see outside of itself, that it's myopic in the American context because it refuses, or the Supreme Court jurisprudence and equal protection and all that, color blind, right? Gives a nice reference to it. They're blind to subordination and they insist that the law be so as well, where, and although they're fine with it recognizing many other things. And so Afro-Atlantic jurisprudence, to the extent it differs from American jurisprudence in an autopoietic way, is that yes, it would accept text, which is again, some of my critical theorists would not, but I think Afro-Atlantic jurisprudence would accept that text is important, that intent is important, that purpose is important, but that we absolutely insist that unintended consequences such as group subordination be considered in legal interpretation, because we know that such things come through hidden agendas, and the purposes that are described are always not the purposes at play. So how would I have the law in Afrolantica look outside of itself? What construct would I inject? Well, I've mentioned before that the construct that I'm advocating is called asymmetrical market imperfections. We're going to reference that again at the end, but at the same time, getting more deeply into what I am calling asymmetrical market imperfections. We're going to go into that the very next episode. That's episode 5, right? All right. So let's take a break and pull back and talk about, again, what is autopoiesis? Where does it come from? Where did I get it from? Okay, so if you want to look up the theory, Nicholas Luckman and especially Gunther Twebner, I hope I'm pronouncing the name right, Gunther Twebner, the autopoiesis of law, right? And again, it's that think about a living thing, right? A person. we are connected to our environment. We breathe the environment. As a matter of fact, we're not even solid, right? That X-rays and other things go through us, right? Even though we see ourselves as solid, right? There are things that are so small or whatnot that it goes right through our body, right? So in that way, I think that's the easiest way to suggest that we are actually connected to the environment, that there's really no separation between us and this world. Yet, here we are, right? Here we are. I am me, you are you. I am not this chair, I am something different. So, if we're connected, if we're all connected, and again, people connect law to everything, history and whatnot, and suggest that it's all this. On the other hand, others suggest law is so specific unto itself. Well, the autopoiesis suggests that no, you are a living thing or ideological concepts. Let me start there. That ideological concepts are best seen as living things, right? That they are in fact connected to their outside environment. However, they are distinct. And what makes you distinct from your environment? What makes you distinct is you reproduce yourself. You ingest things from the environment, you drink from the environment, you breathe from the environment. But when you scratch yourself, when you cut yourself, your cells regenerate itself. And you also have an internal logic to yourself and even subconsciously that reproduces itself upon the information that it's fed. So even though you are connected, everyone is connected to each other, we're all in this together. However, on the other hand, we are a distinct individual. Now, that distinction, that individuality, right, doesn't mean I can just do anything I want. Right? I still have to operate within this environment, and therefore my internal logic has to be is constrained by utility. Right? I have to be useful to people in this world, and not only that, things in this world are useful to me. And so there's a limit on, again, what I can make up as my own language. Sure, I can do it. I can have my own internal language and say blue is red and red is blue. However, if I'm going to interact with my environment, then I have to adjust my logic towards being useful, right? Okay. Now, again, they also it's ideological concepts are living things, and that they are systems of discourse. What does that mean? Systems of discourse. That means the thing in and of itself can't be known, right? Excuse me. That the thing we're going to talk about Immanuel Kant right here. We're invoking his difference between the phenomenon and the noumenon, right? The thing of itself can't be known. I am Andre Smith. You can't know me, and I can't know you. Even if you hear the words out of my mouth, I could be lying to you, or I could be exaggerating, or I could be minimizing, or whatnot. The true Andre Smith is only known to me, and maybe I don't even know myself. Who knows? We'll go there another time or whatever. But what you know about me is what you've heard, seen, and whatnot. So we don't know what truly is love, or we don't know what truly is law, or we don't know what truly is anything, right? That puts us in, I guess, a godly position. What we know is all that has been said about the thing. Right? Now, it could be accurate, could be not accurate. However, when it comes to what that thing is, autopoiesis embraces basically almost everything that is said about the thing and incorporates it into a collective understanding, right? And that has complications, right? Because who gets to inject the system with discourse affects its internal logic, right? Because that's the next part. Not only is it a living thing, it's a system of discourse that operates under its own logic. It's what's called self-referential, right? That its goodness or badness, its rightness or wrongness depends on the system inside of itself. And again, that's when I think that's one of the important things about using hip hop to describe autopoiesis, because I think it's easy to understand that within hip hop, if you are deep within hip hop, if you consider yourself hip hop, it explains why the norms within hip hop seem to be absolutely unresponsive to those in society. What is good or worth valuable within hip hop, it refers to its own logic, and we'll get there in a second. But then the question becomes again, where do its initial premises come from? How does it adjust to its environment? If it is this system of discourse, if it does operate its own logic. So let's talk about autopoiesis, if that's our theory, and hip hop. And so we're going to apply this to hip hop before we talk about law. Now, again, let's start from the beginning and be humble. When I talk about pragmatism, there's two types of pragmatism, at least, right? So there's their everyday pragmatism, and I invoke that when I say that we shouldn't be so chauvinistic about textualism, intentionalism, purposivism, modern dynamics. That they could be appropriate in different situations, or we could consider them all at one time, just using different levels of emphasis for each one, or different levels of discounts for each one. That's pragmatic. That's not saying, oh, I do textualism and nothing else is worth anything, right? To me, that's a bit what I like to call chauvinistic. So there's the pragmatism in that we are honest about the value and also the flaws of each thing that we do. But philosophical pragmatism is a little deeper than that. It's sort of a relativist in that the idea that there is there's two ways. On the one hand, you could argue that there is no truth, right? That everything is relative, that your truth is your truth, my truth is my truth. As far as the autopoiesis is concerned, it has an internal truth. Or, or you could take the tack to say that there is, in fact, a truth, but humans don't have access to it. We did not create this world, right? So to say that because I have, as a human, have a particular conception of what is this or that or the third, and it is right forever and for all time, just from my personal feelings, doubtful, right? And so to the extent this world has been created, and let's say it is created by a creator or God, I believe that my truth is consistent. What I believe is a little t truth. I mean that I am being consistent with all the things that I know. I am consistent with all that I believe that I've heard or said that is in fact reliable. And when judgment day comes and I get to ask, how close was I? Right? And so I think we as humans need to be humble and understand that we do not know the essence of the thing. What I am offering is the definition or the description that I believe is most useful, which is most consistent, which describes the thing consistently in past and also predicts what the thing is or will do in the future. Okay, so since I don't know the thing in and of itself, all I know about the thing is what's said about the thing. So let's talk about hip hop. The first time I heard Rapper's Delight, I was walking to school and it was either the third or fourth grade, 19, whatever, 78 or 79. And Pilar Fernandez, hi Pilar, Pilar Fernandez was singing it walking down the Gompers Elementary School, and the chicken tastes like wood. And I was like, what are you talking about? When she was telling me about this new song. And so at that time in Philadelphia, Jazzy Jeff was what on WKDU, Lady B was on WHAT, and me and my brother used to sit and record over my dad's 8-track tapes every Sunday, Count Cool Out, Super Rhymes, and whatnot. And we knew that we were in on something new. And I'm in from Philadelphia, so that's an interesting. We're going to bring this up later. So I was part of the expansion of hip hop out of New York to the other parts of the country, and as I guess what you would call an early adopter or whatever you would call it, I feel a part of it. I feel like I'm responsible. This was at a time when people told us that it wasn't bad music, that it's not music at all. I was like, why can't it be bad music? Why does it have to be not music at all by our parents? And of course, now 20, 30, 40 years later, we're telling our kids that your stuff is terrible too. They told us the same thing about hip hop, right? Remember, it was that hibbity hop shit. Right, it wasn't even hip hop music in a good way for a while. So that begs the question: what is hip hop? Right? what is it precisely? Especially when hip hop, we get into arguments about that is or is not hip hop, that is or is not rap, that is or is not trap music, or that is right. And then we had phenomena like hip house and other things like that. So, and now we're talking about old school hip hop, right? What is it? What is the definition? Now, there's some, I will acknowledge that there's some utility to leaving things undefined, right? That because it lacks a precise definition, maybe that's why it's expanded so far. Maybe that's why it's helped take over the music industry all across the globe. On the other hand, not having a definition means that no, you can't exclude, and you can't exclude for even good reasons. If you are to argue that someone is appropriating hip hop, well, then what is it that excludes them and says they can't contribute to what hip hop is? If you can't define something that takes people out of it, then how can you say that they're appropriating the culture when, right, the culture by definition embraces them because there is no definition, right? And so we think that hip hop is rapping or whatnots, right? So let's go through kind of how um, society. Let first of all, let's talk about, let's apply the system of autopoiesis if we're going to talk about hip hop as a thing, and we're defending autopoiesis. Um, then that would mean hip hop again is a discursive system. It's described by those who call themselves hip hop and say that they're discussing hip hop, right? And we reject, or at least autopoiesis rejects, that we could know precisely the absolute true definition of hip hop. As a matter of fact, let's ask a question: did God create hip hop? So, if God created hip hop, I don't know. If he didn't, then again, I don't know if we have a true hip hop. Now, if God did, or someone, or nature, or whatever created hip hop, or if hip hop has a absolute essence, then who has the authority to claim it? In other words, we're talking about natural law, right? People talk about what is the our rights imbued to us by the Creator, right? And we talk about rights that come out of the Bible or other religious texts, and some even talked about the laws of nature and want to import them into public law. And the question always becomes, well, who has the authority to claim what is natural law? Who has the ear or the eyes or the ability or the authority to represent God here on earth, right? Now it makes sense. So under that understanding, doesn't make it makes a little more sense that Catholics would have a pope, right, or that others, an imam or caliph, right, that someone has the authority to set what law is, because otherwise, to the extent everyone has a personal relationship with God, then you have a different natural law, each one to unto itself, right? You can't tell other people that they are quote unquote wrong. Now, the interesting thing about natural law is, especially now, if we're going to cross over and talk about hip hop and the natural law or the natural description of hip hop and who has the authority to describe it. Well, as a hip hop head, 5, 10, 15, 20 years ago, I bet you 50% or more would have said Africa Bambaataa, right? As kind of the prophet or the one who had the greatest authority. Maybe Cool Herc, maybe Red Alert, but as far as taking hip hop from just a musical genre and making it into a culture, it probably would have been Bambaataa. Fast forward to 2017, and because of the child molestation allegations, Bambaataa's reputation is in the toilet. And that gives, in our context, what I think that suggests is, or is a warning, right, about lionizing or selecting an individual that is going to represent truth, right? Because that person will probably, and I'm not suggesting that everybody's going to fall like Bambaataa, or you're going to, but at the same time, you don't know what's behind anyone's closet. And so to choose someone to be the arbiter of law for God, to me, always will set you up for disappointment. Again, if we were going to talk about the Pope now in Catholicism, right, that they have the authority to determine what law is, but because of their child molestation issues, right, that authority becomes weakened and illusory. So that's how I dispose of, I guess, natural law. That number one, it's not knowable to begin with. You got to wait till you die and ask the Creator yourself. Number two, even if it does exist, who has the authority to express it? So I am more of someone who's into, I guess, the more universalist types of interpretation, right? How do we use a logic or a formalism to determine what the thing is, right? Do we use the original text, right? Do we use the intent of the authors? And in terms of hip hop, no, that doesn't mean we would make Bambaataa or whatnot the Pope or the minister or whatnot. But what we would do is credit Kool Herc, credit those and say, what did they say hip hop was? All the people in 1973, numbers 1974, 1975, what did they say hip hop what is? What did they understand it to be? If anybody was purposely trying to create hip hop, what was their intention as to what would it consist of? And again, from an early age, we learned that hip hop was MCing, DJing. Well, let me start with DJing. The DJ comes first. DJing, MCing, graffiti, and breakdancing, right? That those were the four elements of hip hop, right? That the people, and think of this again as collectivism, right? That between 1973 and let's say, I don't know, 1983, in 10 years, the discourse, and when I say discourse, the speech, the memes, the writings, the recordings, the parties, and all that, everything that was said about hip hop seemed to coalesce naturally, if you want to look at it that way, coalesced around this idea that hip hop was MCing, DJing. I did it again. DJing, MCing, b-boying, basically graffiti and breakdancing, right? But then fast forward another 10, 20, 30, 40 years, right? As graffiti and breakdancing start falling to the wayside, as the MC rises to prominence and producers become more important to DJs, right? What happens to those older elements? All of a sudden, are we not allowed to call this hip hop anymore because you don't break dance, because you don't have graffiti? Now, we're gonna pause on that and draw a line towards, or an analogy to, again, the U.S. Constitution. You may have heard arguments like this before. So when we talk about what is the America and the Constitution and what does it mean, right? We had Justice Scalia, who, or I'm sorry, most textualists that want to say that the Constitution, or formalist scholars who argue that the Constitution should be interpreted as it was originally intended, right? That would be basically saying it should be interpreted as Bambaataa, as Kool Herc intended for it to be interpreted. That's in contrast to Justice Scalia, who is also an originalist, but he draws just a subtle distinction that the Constitution should be interpreted as to how the people of the United States understood the words to mean, right? Not how the founders intended, but what the people understood. Those are two different styles of originalist textualism and originalist intentionalism. And so that's a comparison that we can draw to hip hop, right? Is it the intent of the founders from 73 to 79 or whatever? Is it what the people understood hip hop to be between 1973 or during its foundation years? Now, that contrasts, that formalistic way of looking at it contrasts with the consequentialist, right? Or realist. We're going to enter uh, um, we're going to use them interchangeably, consequentialist or realist, right? That what are the consequences of choosing a particular definition? One looks backwards, formalism. What was the original premise, and does this fit within the premise? Consequentialism, realism looks forward, that this is the thing, and defining it should produce this later in the future. And one of the one of the criticisms of realism or consequentialism of by the formalists is that, oh, that it just again becomes anything you want it to be, that it has no standard, that it's unstable and it's nihilistic. And so let's look at that through the lens of hip hop. What was the purpose? Right? We could look at the consequences again in two different ways. What were the consequences the founders intended for it? There's what form they intended for. So again, let's take Bambaataa and say that he intended that the form of hip hop be the four elements. Or we could look at KRS-One and say, or I'm sorry, Chuck D, and say that he said hip hop is the CNN of the ghetto. That's different. That's consequentialist. That means that hip hop has a function, not necessarily a form. And so if it is the CNN of the ghetto, then that means how whatever form it takes, so long as it truly is representing the underclass, then that still becomes hip hop, right? Is it the original intent? Is it the original understanding? Or is it the consequences? And if we talk about the consequences, this is one of the problems with realism. Well, who said that that was the consequence? Chuck D. What authority does he have? Once again, we're all the way back, even with natural law, with textualism. Who said? Who has the authority to say? Who made Chuck D the person who could make that statement and it be respected? Well, the answer to that could be we did, right? You could just disagree with me, or to the extent hip hop heads all over the place say, yeah, Chuck D is that dude, and he gets to help define it, that his discourse, right, his statement ranks higher than others, right? That's how autopoiesis works. Yes, it is a discursive system, but that doesn't necessarily mean all discourse is equal. And again, when we talk about critical theories, insights into the nature of the thing and how it becomes a channel to its subordination, that's important when we say all discourse is not equal. Okay, so there we have our two different ways. I'm sorry. Well, the intent as the founders. There's also the consequences that people outside of hip hop, outside of the founders, want for it. And some people will call this modern dynamics. So again, I work in law schools and I've written on hip hop and the law, and I've published and I've talked with other people who have prescriptions for hip hop that don't necessarily consider themselves hip hop. And so the question becomes, there is the original understanding, there is the original form, there is the intended purpose. But what about the consequences that are recognized by people that don't consider themselves in hip hop? Is that to be important at all? Again, hip hop is criticized for its misogyny. It is criticized by black nationalists for being a tool of white supremacy. Is that to be respected at all inside of hip hop if the discourse is not from inside of hip hop? The autopoiesis says no, right? That hip hop has its own internal logic. However, let's turn around and say yes, but hip hop gets fed. Hip hop gets fed. It has to eat. It has to work within its environment. So on the other hand, one hand, it may change. It may sometimes adjust its logic internally or adjust its expression to account for a C. Dolores Tucker or some types, or perhaps the police or something. But as we see, hip hop is quote unquote hard, right? That's a good trait in hip hop, to be hard. That our autopoiesis does not accept much from the outside. That it is tight in together and resist that type of influence. However, critical theory tells us that you're going to get infiltrated, right? Critical theory says that the wealthy, the powerful, will inject that discourse. They will feed it to you. And so that is the insights that hip hop has always had about the quote unquote rap music industry. That regardless of what hip hop thinks it is, And we can talk about the foundation, we can talk about global or whatever, whoever calls themselves hip hoppers, whoever decides that they are part of this system. There is also the argument that, again, shareholders of the major record companies influence hip hop just as much because those corporations speak and describe themselves, or at least the labels, as hip hop. They inject, and with the money and the resources and the capital they have, going back to capital accumulation, with the capital they have, they inject huge amounts of discourse into the system that says what? That this is gangster rap, that hip hop is gangsterism, that it's ignorance, it's prurience and whatnot. And again, for those of us that grew up with it, it just so happened that that injection of huge amounts of gangsterism went after hip hop by itself, left unto itself, became very politically conscious, right? And so through its own internal logic, it saw itself as being an arm of resistance. However, through our critical understanding of critical theory, and even as much as I praise autopoiesis as a system, I do so because it's accurate, not because it's just what I want it to be. And its accuracy is shown by the fact that a thing like hip hop was created in my lifetime by people like me, and yet control of it is fleeting because the powers that be can inject more discourse into it because they have more capital. The resistance, of course, is that the ranking of discourse, right? That those of us within it try to minimize and discount those things that come out of the rap music industry. And the interesting thing is, from there, what? It bubbles out. That all of a sudden a new thing emerges: real hip hop, old school hip hop, foundation hip hop. Each thing is autopoietic, and those that try to create it or whatnot, right? People that go viral or whatever, you spark a thing. We know about this in the hood. You spark a thing and hope it grows. And so when you're dissatisfied with hip hop or something that's been taken over by outsiders, we tend to migrate to the next thing, populate or pollinate the next living system and try to help it grow. Um, so that is the theory of autopoiesis as applied to hip hop, and I hope that it also sheds light onto why I call the law an autopoietic system. Right? Is the law the text? Right? That back in the 80s and 90s, they had all types of style wars. Right? It was like breakdancing. While we were breaking on cardboard, theorists and legal academies were arguing text versus formalism, and all of it has to do with race. You do understand this, right? That Brown versus Board of Education and whether the judiciary is allowed to protect minorities and whatnot is the essence, absolutely at the essence of the old interpretation wars and whatnot. So I think it's quite appropriate that we rehash it here. And so the idea was the text, and especially again, when we're talking about Straussians, because Straussians want us to focus strictly on the text because their agendas are hidden, right? And so, because the agenda is hidden, they produce discourse injected into the law and suggest, under what we call pretext, that it is for your own good, when in reality it's long, and it will be in the short term, but its long-term effects is to certify, petrify the order, and whether that be the economic order, the racial order, or both. So again, with law, the argument was, well, the text is the law, right? That the law consists nothing of the text that was created, right? The founders created the Constitution. Your legislature creates legislation. Your judges create judicial reports and all that other stuff. And that's what the law consists of, and nothing else. Except the insight to that is can't be. Right, the words on a piece of paper represents badly, right, what the people intended for it to mean, its consequences, all of it, right. And so to hold it to the text, number one, what did that text purely say? Right, because we're not talking about what the individual said, we're talking about the text, and the text is now this thing, and now one of us has to take on the godly duty of determining what that text means true to the creator right? Or what? We can then look at originalism. What did the text originally mean to those who created it? That requires us to be historians, right? To look to go back and try to determine what was going on in someone's brain that was alive 50 years ago, 200 years ago, 500 years ago, and figure out and figure out what they specifically intended. And guess what? It probably mirrors what I intend, right? So it has a chance to be illusory and allow judges to put in their personal preferences. So Justice Scalia attacks that actually. He says, no, it should be, again, the way the people understand. He thinks that's more faithful. Now, it still requires you to be a historian, right? That's a lot of work if things 100, 200, 300 years. And I don't know if judges are competent to do that. But I think it is an improvement over intent. But here's the issue there, and I've talked about this at great detail. Meant to whom? Right? The people of the United States. There, just like there is today. Maybe there were less people in the United States at that time. However, there were people of all walks of life that spoke different languages: French, German, English, African, all types of African languages, all types of Native American languages. And are we ready to exclude them again? That the only understanding is those of white men or white people? And where do we get those understandings from? This dictionary or that one? Again, so it's elite white individuals. Again, it's very problematic as far as a historical perspective and a ranking perspective, and the idea that we get to discount this. So, as a matter of fact, later we're going to talk about the U.S. Constitution, and I wrote an article called "Does It Matter What Slaves Thought Direct Tax Meant in the United States Constitution?" White folks put direct tax in the Constitution and had no idea what it meant. They just put it in there because the people reading it will say, "Oh, okay," and it'll help it pass. That they think that there's some limit when no one even knew really what that limit was or whether it actually existed. And of course, the Supreme Court, after it passed, totally ignored that limitation in a case called Hilton. And so that's why, again, this idea that the text is the law is faulty. It is not unimportant. It is not wholly to be discounted, but does not encompass all of what the law is, right? So as people say, well, the law is the lifeblood, the law is its purposes, the law is what it produces. Um, Law and economics theorists talk about this, that the law is the probability that a particular consequence will occur, right? We know that if you break the law, you don't necessarily go to jail. There has to be a whole process that puts you there in discovery. So the law, even when broken, there is a percentage chance that you will have a negative, I don't know, result or consequence attached to it. So they also say that no, it can't be that formalistic because it's not A to B. You break the law, you don't necessarily go to jail. It's the consequences, and those consequences judges, as we've seen and complain bitterly about, that judges adjust the probability of consequences with respect to the law based on your perceived worthiness to them, which is all spiked with subordination as far as gender, race, etc. Then there is, again, what are the purposes of the law? Trying to figure out what the purposes the founders intended, isn't that just about as problematic as their original intent, the form that they wanted to take? Justice Breyer of the Supreme Court now says that the founders intended to create greater public participation in our democracy. And the interesting thing is, he doesn't say he finds that through reading the Federalist Papers. He says he just reads it from the document, that it's text-based. That if you look at the document itself, it produces an obviousness of consequences that it aspires to be a great political democracy where everybody gets a say. And so he interprets law today, especially over controversial issues, as to which interpretation offered to me brings in a fuller, greater participatory democracy, right? Noble, noble. However, how do we know that that's true? How do we exclude other conceptions, right? Because that argues that it comes from the founders. How about the idea of privacy? How about the idea of that it is intended to reduce group subordination? It would be very hard to claim that the founders intended for the document to combat group subordination, seeing as most of them, or a great deal of them, were either slave holders or even if they didn't own slaves, still believed in the myth of black inferiority. So group subordination, or combating group subordination as a constitutional norm, would have to come from something outside of text, intent, and purpose. It would have to be modern dynamics or dynamism. And that's precisely what, or the best definition of what you will hear conservatives call judicial activism, right? That these consideration of modern dynamics is outside the realm of the law because it's outside of authority. Why? Because we're supposed to be a democracy. And think about text. It came from the legislature or the founders. Think about intent. It relies on the legislator and the founders. Think about purpose. Purposes are the consequences that were intended by the legislature or the founders. So judges, considering all of those three, are subordinate to the legislature, and people believe that that's consistent with democracy. On the other hand, to consider dynamics, which was not considered by the legislature or the founders, says judges, it gives them more power. And to give them more power in a democracy makes us not a democracy or less democratic. I can concede the less democratic part. I can't concede that we are just not a democracy because we allow judges to consider modern dynamics, especially if we require them to consider the other three. Text, intent, and purpose. And so autopoiesis in American jurisprudence and autopoiesis in Afrolantican jurisprudence, in my view, allows the best allows us to envision a system that has to see outside of itself, the consequences that are intended for it, and simply the consequences that are affected. And not only that, because we know that an autopoietic system is susceptible to large amounts of discourse, and because we know that those elites that want to inject it with discourse are going to do it in an unstated way. Again, this is not critical race theory. This is actually critical legal studies. To the extent we, Duncan Kennedy and the rest, since we know elite powers are going to inject the thing with discourse, then the thing has to be able to see consequences that are unstated, to see consequences, to consider all consequences, because not just the short term, but the long term ones, to the extent we believe that group subordination, racism, wealth inequality, plutocracy, to the extent we believe this will tear at the fabric of the nation and destroy us all, then absolutely the law should defend against the annihilation of the nation and consider group subordination, regardless of whether it was intended by a specific set of legislators or not. Right? I think I want to suggest a book that you can get a lot more information. I mean, there's plenty, but the one book that I would refer you to that can give you a sense of text, intent, purpose, modern dynamics, and law, and even critical legal studies and critical race theories, place and all that, is a book called Under Cover of Science by James Hackney. I believe he's still at Northeastern. He's written some other books about the old style wars back in the day, or theoretical wars. And so Under Cover of Science by James Hackney. If you're interested in what I was just describing as far as legal interpretation, please get that book. And hopefully the things I said were consistent with it, because he's more of an expert than I am on that particular issue. So I want to conclude with what that means going forward. So to the extent law is an autopoietic system, to the extent I argue that Afrolantican juris is an autopoietic system, it respects textualism, it respects intentionalism, conformalism, it respects realism, yet it also heeds the critical insights and is cognizant of those who inject discourse into the system and for its purpose, and therefore the construct that I insist Afrolantican jurisprudence should adopt is asymmetrical market imperfections, right? That the equal protection clause or whatever's like it inside of the jurisprudence of Afrolantica would understand that group subordination is always afoot, and especially in a material way, and therefore to see that would be the construct that the law would use to see outside of itself to describe material subordination. One of the reasons why it's important, it's a formalistic type of realism, right? On the one hand, we're looking at consequences, group subordination. On the other hand, I'm suggesting a formalistic way of doing it by taking the structures of the market, the four pillars of the market: profit maximization, perfect competition, perfect information, no transaction costs, and using that as a lens to see group subordination. That, first of all, we know the government is authorized to fix the economy or fix the structure of the market by helping perfect information, by removing barriers to competition, by redistributing transaction costs in a more equitable way. So if that is a legitimate duty of government, then it is also a legitimate duty of government to fix those market imperfections when they're asymmetrical, when the barriers to entry are different and disproportionately against Black folks or women or whomever, to the extent information and stereotypes are different and disproportionately egregious, to the extent transaction costs are different and disproportionately levied upon one race, one gender, one sexual orientation, etc. The jurisprudence within Afro-Atlantic jurisprudence needs to be able to see that, regardless of whether it is intended as a consequence, that it is also part of a dynamic that the eyes of the body of law should be wide enough to see. So in episode 6, we will continue this discussion of asymmetrical market imperfections, and I will describe a little more precisely what it is I'm asking judges to recognize. And more so, I'm asking, what am I asking lawyers to argue in front of judges to get them to recognize that all types of racist phenomenon can be described in an economic way, and not only is it racist today, it it helps to perpetuate a market that will reproduce subordination and racism tomorrow. All right, good night, and see you on our next episode 6.